Get started. All right, I think now we're live. Everyone, welcome in to today's sessions. And then we're going to take a little, maybe it's just a minute for everybody to sit tight and joining in. I know that this has been a very trendy topics. A lot of our F1 community, we care about this dearly. And then right now, today, we're very excited to invite a lot of the speakers from different expertise, different perspective to bring in a comprehensive sessions. Hopefully you guys can have a lot to take away from today's sessions. We're also live streaming on YouTube. So if you can hear me okay, if you can, hear me right, if you can see my sharing screen, definitely feel free to leave me a reaction. So I know that people are joining. We already have 500 attendees joining us from the Zoom side. So definitely a lot of students from our side as well. So thank you guys for joining in, and then I'm going to dive right in. So I see people raising hands. We do have designated Q&A sessions later on. So we're going to do presentation, Q&A, presentation, Q&A, and we're going to follow by that order. And then, so if you guys do have a question, feel free to use the Q&A sections and send in your questions then. So a little bit of brief about what is going on. So the DHS, as you guys may know, has published their final rules, and then they have made the publication on Friday last week. So this is kind of like a rapid fire session where we invited the expert to kind of bring in the newest, what is going on, what is the trend when it comes to the final rule, what's the duration of status rule. And then it takes effect. Ideally, they want it to take effect in September 15th. So everybody have some time for now to get used, to get educated, to get to know what is this about. So I wouldn't touch too much on the details of what the rules are. And then we'll dive right into that with our first speaker. So speaking with the speakers, today, we're happy to invite five speakers, those who are all expert in their field. I'm very excited to welcome Adam Cohen, who is an immigration attorney and partner at Siskin Susser, and he has been a long-term practice immigration attorney. He's going to speak on, what this rule actually are as the opening part. And later on, we're going to invite Marta Main, another immigration attorney, to speak on other subject. Also, we are excited to have David Gluckman, another attorney, and also excited to have Nathan and Joshua join us from the school side, kind of to talk about what their perspective when it comes to the school practices and how to guide students for the next steps. So a little bit information about Go Elite. I know you guys have signed up from our side, from extensionofstate.com. This is a platform that are built to help students navigate this uncertainties, navigate the time. So this whole session will go 2 hours. So don't worry if you miss some part, you'll still get the recordings later on. And then we wanted to build on the current existing knowledge to share about the records, the decision, the deadlines, whatever are going to happen. And then I wanted to emphasize these are for education purposes only. So anything that we talked about today are not legal advice. And then this is are just for general education purposes. And then just a little bit information about who we are as the host, the creator of today's event. So we are a education company based on Pasadena, California. We are partners with U.S. universities. We're mainly focused on the day one CPT services side. We have serviced more than 20,000 students, and we have partnered with numerous universities. So we're certified by ARRC, and then we offer 100% free application or consultation services to our students. So if you are interested, definitely feel free to book a call with us later on and then consult with us on your next steps. So without further ado, I'll first invite our first speaker, Adam, to unmute. And then Adam, maybe you can do a little bit of brief intro about yourself, and we can go ahead and get started with the session.
Sure, absolutely. Thank you so much, Ryan. I'm going to share my screen as well. Bear with me just a moment. Okay. Ryan, do you see this?
Is loading. Yeah, we see that right now.
Okay, perfect, perfect. Well, welcome everyone. So glad that so many of you have made it here for this presentation. I want to thank Ryan and Go Elite, the whole team, for inviting me to speak today. It's really a sign. It shows your interest and you taking ownership in your own education of this process by you being here today. So, I think that that's fabulous. So what we're going to be talking about, I'm just going to be sort of setting the stage here in terms of this new rule and what's coming. Like Ryan said, there is a 60-day implementation period. And so there will be some time to get acclimated to how this process is going to work. And I know that universities are doing much the same. So my name is Adam Cohen. I'm a partner with Sisk and Susser, as Ryan mentioned. I'm active in a lot of the different organizations that kind of have our ear to the ground, as you might say, in the immigration, the academic immigration sphere, American Immigration Lawyers Association, NAFSA. I'm part of committees with many different organizations. And I also put out the Academic Immigration Handbook, which is now in its fifth edition. And I'm going to have to work on the sixth edition very shortly because of everything that's changing that I'll be talking to you all about today. So let's just talk a little bit about where we're headed. We're going to talk a bit about what duration of status is, right? To understand that it's being eliminated, we kind of have to know what it is in the first place, right? So we're going to talk about that. We're going to talk about why is the government choosing to end duration of status. And then we're really going to get into the crux of this, right? What is the summary of the rule? What are the implications? What are the next steps for you as the international student or exchange visitor? And then we will take that brief Q&A period as well. So duration of status is, if you've ever entered into the US or you change your status to an F1, right? You see this duration of status. You're admitted until duration of status. What exactly does that mean? That means that while you are making normal progress in your course of study or to your research obligations and objectives, that you are allowed to remain in the US as connected to your I-20 form as an F1 or your DS 2019 form as a J1. So the loss of status in this context is really connected to enrollment for less than a full course of study, working without authorization, rather than a specific expiration date or admit until date. Accrual of unlawful presence. You're going to hear a lot about this in the days ahead. This is these 3-year and 10-year bars to return to the U.S. If you accrue, more than 180 days, you get this 3-year bar upon departure. If you accrue more than a year, it's a 10-year bar to return. Okay, what does that all mean? This accrual of unlawful presence for F1 students, for J1, it's always been connected to a formal finding of a violation by an immigration officer or by an immigration judge. That's going to change, and we're going to talk a little bit more about that as well. So the government wants to take this duration of status and they want to say, you have until this date. Okay, they want to give you an exact date, a certain date to put it in line with a lot of other non-immigrant categories. Now, I could talk about the policy reasons why this makes no sense, why I think it's a terrible policy from the government, but we're still here. And I only have 20 minutes to talk to you. But we're still in this situation, right? So I want you all to just understand a little bit, right, that the government, they think there's a lot of there's just a much larger population of F1 and J1 students than there were in previous years, when before duration of status. And they tried to pinpoint some different violations and issues and concerns that they have, even though Fs and Js are among the really the most tracked and monitored class of non-immigrants in the entirety of the US immigration system. But basically, with their final rule, they have a new rationale, right? So they're basically saying, well, you guys, you go to your university and they will make decisions about program extensions, but they're making them on academic and programmatic grounds. Are you, still pursuing your course of study, et cetera? USCIS, the U.S. Citizenship and Immigration Services, part of Department of Homeland Security, they say, well, but DSOs and ROs, the universities, they're not looking at whether a student is maintaining status. whether they have committed certain crimes or whether they're working without authorization or things of that sort. So they're basically saying there's a dual process. Universities have their side and we have their side. We have our side. And it's important to understand that when we talk about sort of the implications of this second layer of review by USCIS. So, what does the final rule do? So it's effective 60 days from when it was published. So it will be effective on September 15th. It is providing an admission for a specific period of time, which is the shorter of 4 years or the program end date on your I-20 or your DS 2019. We'll get more into that later. Basically, if you are going to exceed this, the shorter of the 4 years or your program duration, you have to either extend your status with U.S. Citizenship and Immigration Services by filing this Form I-539 form with USCIS, or you have to travel and you have to re-enter into the U.S. with your new I-20 and your DS 2019. There is also this provision for, oh, actually, I should say, when you file this as a student, when you file this extension of stay, you are able to continue going to school. I think that's very important for you all to hear, as long as it's been timely filed. Okay, so it's filed before the end of your status, of your program end date. And so you're able to continue studying. Now, anything that involves work, okay, anything that involves employment authorization, your CPT, curricular practical training, your on-campus employment, any type of severe economic hardship or special student relief type of authorization, you will only receive a 240-day automatic employment extension, okay? So that means that after that 240-day period, which by the way is after your program end date, that's when the 240 days begin. Um, Once that 240-day period has run, it cuts off the ability to work until a decision is made on the extension. One is in a period of authorized stay, even if the extension is still pending past your program end date, you're still allowed to stay in the US, but you just can't work after, and you're still allowed to go to school, but you just can't work after the 240 days have concluded. So that's something to certainly be mindful of. There is an F1 grace period reduction for those of you, commonly aware that there's a 60-day grace period for F1s. That is going to be shrunk down to a 30-day grace period. There are also these curricular restrictions, is kind of what I'm calling them, that are apart from this extension of stay. There is a cap of 24 months lifetime cap for English language learning. My understanding is that this cap starts to take effect from September 15th, okay? They're, looking at the reliance interest that students would have had when they came in. They didn't know that there was going to be a cap. So basically, the government is trying to, I think, position themselves well to not be sued, to really have this cap become effective, these curricular restrictions to become effective after September 15th, right? So that's when that cap begins. There will be restrictions on transfers during the first year of your undergraduate time at the institution that issued the I-20. So there will be restrictions on transfers and changes of educational objectives and majors, unless there are extenuating circumstances. So there is a small exception for that. There is no transfer allowed for graduate students prior to program completion. There is also an extenuating circumstance exception for that. But as you can see, that's broader for graduate students than it is for undergrad students. They are also prohibiting something called lateral or reverse matriculation. So that looks like bachelor's to bachelor's. That is, you're moving laterally. Or a bachelor's to associate, right? That's kind of where you're going downward. They want to see an upward trajectory in the progression of your education, right? So they're looking at bachelor's to master's, for example, or associates to bachelor's. They are restricting the lateral or reverse matriculation. And then there is the transition period. This is also going to make this a little bit more concrete for you all because I'm a visual learner. I think it helps a lot to, really see this kind of charted out a little bit. So let's say you are here on the effective date, September 15th. You don't intend to travel internationally yet. You are allowed to remain the shorter of the program end date on your I-20 or your DS 2019 or the 4-year period, right? Whichever is shorter. Now, just keep in mind, there are English language program restrictions, as we talked about with the cap there, the 24-month cap. And there are also certain J1 category restrictions too, right? So that may not be as relevant to you all, but there are other regulatory restrictions that might come into play. After this end date, you basically have a 30-day grace period as a J1, and you have a 60-day grace period as an F1, right? And you have to file for an extension of status, or you have to be readmitted with a new I-20. Well, now you say, but I thought you said the grace period was being shrunk down from 60 to 30 days. Why does it say 60 at the top? And that's because that's also goes back to these reliance interests, right? You haven't done anything yet. You haven't filed a new extension. You haven't traveled after the effective date. So you relied on the fact that there would be a 60-day grace period, and a 60-day grace period there will be until it's over, and then you have to file that extension or you have to be readmitted. Okay. So it'll be there initially until you extend or you come back in. Another thing I want to point out, right, is the extension of status should be filed before the grace period in ideal circumstances. Okay, so it would be much better to file that extension of stay prior to the program end date. Why? Because if you do that, you will receive the 240-day automatic extension of work authorization. Okay. That 240-day extension of work authorization, like for your CPT and your on campus employment and all of that, is only possible if you file the extension of stay before the program end date. If you file it during the grace period, you'll be in a period of authorized stay. You can remain, you can do your studies, but you cannot work. Okay. So just be aware of that. For others who are traveling internationally after the effective date, or once they file their extension of status, that's kind of the second part here. They will have the shorter of the program end date, um, or 4 years, and they will have the 30-day grace period, right? Because at that point they have made moves to now put themselves into this new rule, which will happen to every student eventually. There is one other thing I wanted to note here at the bottom that you want to be aware of, which is a 6-month rule for post-completion or STEM OPT filings to avoid extension of stay initially, right? So this is where the work authorization form I-765 for your OPT or STEM OPT is filed in the 6-month period after the effective date. So this would probably take us into March 17th or 18th of next year. If you can file, if you're eligible to file the 765 before that time, you will be able to remain in the US until that program end date on that OPT, without having to file the 539 extension of stay. The changes are really mostly technical from the proposed rule. I'll just note again that the transfers for undergraduate students and graduate level students, they're restricted, but there was a note, and I know this definitely changed with the graduate studies, that there is an exception that is authorized for extenuating circumstances. Other than that, it was a lot of largely technical changes, but that's the main one I wanted to raise to you all. So, what are the implications of this final rule? I'm going to kind of rush through these because I want to get to just some additional tips for you all to think about. So, One very important thing is to understand that an extension of stay is a vetting check-in for the government. Okay, that's why they're doing this, so that they can do biometrics, they can look at your social media, they can look at your intent. Do you have a green card process? Are you at the very end of a green card process? That may come into play and be significant. Do you have the financial resources? This is the same, test as there's been for those who change status, for example, to F1. Are there compelling reasons or documented illness or other exceptional circumstances for you to move on in your course of study? A denial will start the accrual of unlawful presence, right? So, or remaining after the expiration date. It's probably the later of those two things. So, if you have a denial after the expiration date of your program end date and the grace period, that's when you would start accruing if that was a timely filed extension. So, just realize the unlawful presence works a little bit differently, and denials cannot be appealed. This framework is going to put a burden on universities. It's going to put a burden on the student. It's going to put a burden on USCIS adjudicators as they're looking at these applications. There's going to be a lot of extensions, and they're not going to be expedited. They're probably going to take time. Will the 240 days be enough for the continuity of your work authorization, right? If you do everything right, you file the extension before your program end date, will it be adjudicated by the time the 240 days have run? Um, and that's an open question, but I will tell you that in the final rule, they do recommend applying 180 days in advance of your program end date. So it's very important to get started early to give the extension as much time as possible. You'll have to consider whether you will use legal representation to help you with this application, from the beginning to make sure that everything is proceeding smoothly, or whether if there's just particular circumstances that call for it, you will use an attorney. These are going to be some things. There's some government fees you'll have to think about as well. There will be issues at the ports of entry. So if you leave and you want to re-enter instead of filing the extension of stay, that is also possible, but it's going to be a learning curve for Customs and Border Protection as well. Um, and yeah, these are just some small things to consider, that will be changed by the grace period kind of shrinking down and how much support you may come to find from your university. They're going to put out a lot of guidance and things of that sort, and you're going to want to be aware of all that. So just to close on this, what can you control as the student, as the exchange visitor? You can educate yourself. You can attend these sessions from Go Elite and from other organizations and from your university. You can read all communications about the final rule from your university and talk to your DSO, talk to your International Student and Scholar Services Office. Be aware of your program end date on your I-20, okay? That end date plus 30 days, or I guess 60 days initially if you're not traveling, is going to be the extent of your stay on 9/15/2026, right? So you want to be familiar with that. In certain cases, you may be able to get that I-20 extended. It's just going to depend on how the university is going to handle this situation kind of moving forward. Universities are working to sort out a lot of this, make sure to look for messaging from them. Understand the effect of international travel, okay? 9/15 26 begins this rule. Please do not travel on 9/16/26. And the reason I say that is it's not a forever thing, but just to understand it will be a learning curve for CBP. There may be some level of chaos and things of that sort. You just want to be aware of the effect that the international travel will have. And when you come back, you will have a date certain at that point. So just be aware of it before you travel. We talked about that 6-month transition rule. Be aware of that as well. Think about these curricular restrictions that we talked about. Keep good documentation of your CPT and OPT training. Just remember that that is going to, they're going to look at whether you've been maintaining status, whether you've been progressing in your course of study. this is a good opportunity. Just I'll plug Go Elite here, Ryan. Um, when it comes to day one CPT, we know that that's something that's being scrutinized. It's good to work with organizations that really, know what they're doing in this area and can provide good consulting and assistance here. And OPT training, making sure like if you are volunteering, you don't have pay stubs, that you have some type of work product to show for it that shows that you were actually engaged in that OPT. Good social media, hygiene, of course, being aware of that. Always pulling your I-94, following your international travel. I will just tell you that you can be limited on your I-94 by your passport expiration. So you always want to electronically pull your I-94 to know exactly what it says after you have crossed the port of entry. Um, what you can't control but should monitor. Litigation is being discussed. Litigators are looking this over. People are thinking about suing. It may happen. It's certainly possible. Stay informed. There is the possibility that Congress could move to issue a joint resolution of disapproval for this regulation. I would not count on it. Congress hasn't really done very much in the immigration space unless it was something on the more restrictive side. So I would not look to that as a saving grace, but just be mindful. There will be other clarifying policies from the government, and there will also be policies developed by the university in response. Keep yourselves informed. Tomorrow, we're actually going to be doing a weekly live stream on this. We'll be talking even more about duration of status. It's on our YouTube channel and our Facebook channel for Sisk and Susser. Here's some of my contact information. And Ryan, I think I nailed it in the space we needed. So should we open it up to some Q&A?
Yes, it's wonderful. Thank you so much, Adam. I think this
Sure,
this
no
gives
problem.
everybody a general rule of thumb when it comes to what this rules look like and what should be the necessary next steps as a student point of view. Because I believe most of the audiences coming in today are those students being affected in schools, OPT, day one CPT, coming from those backgrounds. So we did collected a lot of questions from the Q&A, Adam. If you are and then the audiences, you guys, if you could see the Q&A sections down to your screen, you will see the most upvoted questions, and then we kind of wanted to go to those ones that people want to see
Oh, there we
see the
go.
most. So the first question is, in this situation, right? If I apply for a day one CPT starting next January, and then even before, or actually even my STEM OPT is valid until February, which is, I apply for day one CPT before my STEM OPT ends. Um, and at the
Mhm.
same time, because extension of stay, the students need to apply for an additional application for extension of stay in that situations. What are the risk factors? And also, do you suggest starting the course before the rules takes effect? Maybe they will give up some of their OPT and get enrolled into a second program, or a same degree program.
Oh, that's interesting. Yeah. I mean, the first thing I kind of look at is I just sort of look at the math here, right? Because you have a STEM OPT that's valid until February of 2027. So that's going to be the program end date there, right? Now, that means that if you are enrolling in this day one CPT program, right, that's going to require an extension, right? Because the STEM OPT, that's already there. So by the time we get to 9/15, there's going to be a need to file this extension of stay for the day one CPT. Um, in terms of the risks, I mean that's the way that you would handle it for the extension. Now, I think the risks are we're not entirely sure, right, how the government is going to be adjudicating these. What is going to be the level of scrutiny? What kind of evidence and supporting documentation are they going to want to see? So I think that's a part that, it's hard to mitigate because we're just not sure what that adjudication is going to look like. Do you suggest starting the course before the rule takes effect? That's a hard question. I guess the question asker is, thinking, well, do I sort of avoid any of that type of scrutiny if I'm already there, right? And I guess if you start that program, then you have until the program end date, um, part of that I-20. I guess it depends on how far does that I-20 go, right? How far does that program go? Is there going to also need to be another extension while the student is still in the day one CPT program? And in which case, it's not really avoiding the scrutiny, it's just kind of deferring it down the road. So it's hard. It's one of these things where it's going to be a personal, personal type of decision. So it's going to be, kind of hard to say. Um, I don't usually tell
Right.
people
And
meet
then I do wanted to
blindly
add a
because of
point from Adam's adding from what Adam said. It's just that for now, each students have your own unique situation. Some of you are first year OPT, some of you are near graduation, near stand OPT ending, maybe applying for a stand OPT at the moment. So based on these situations, it's hard to know whether or not transition into a new program is the best option. So I would say a general rule of thumb is maybe you can click the link below to our resources, book a free consultation with our team. Once they learn about what situation, what stages you're in, they are able to give you a more comprehensive suggestions comparing to just give you a general answer for now. So Adam, maybe we can do another question.
yes,
This
please.
one is also focused a little bit more on the rule and then after being effective, what the implication would be. So this question is from Meng Yuan, and this person is asking, um, my main concern is whether I can apply for a second master degree after September 15th. Is there any particular area in the rule that permits or forbids that to happen?
Yeah, so I mean, that is the issue of the lateral matriculation problem, right? So if somebody is, going to be moving into a lateral degree, a second master's, that may be a problem after September 15th. I think it's going to depend on whether they build in any other types of exceptions for that. But that's going to be, I think that's going to be affected by the lateral matriculation.
And then for the second degree issues, I think in one of our sessions coming up today soon, that our attorney David Glockman is also going to touch on the day one CPT side and then also the second master side. So I believe he will go into more further details within the rule about the second masters, and you guys could definitely stay tuned in terms of what the specific if he has any references on that part as well. So Adam, I'm thinking maybe we can do one more before we move on to the next session. Let me just
Oh,
quickly
absolutely.
refresh it. Okay. All right. Next question is more general, and then we love general questions. We don't love very personalized questions because we don't understand the context. So for this person, he or she mentioned, do you need a job offer for DSO to authorize day one CPT? How does that work if the authorization takes months to come? I know that we also have DSOs in the audiences. I mean, in the speaker stands, but also in general, just for this question, what would be the right answer for this? Do you need a job offer to authorize day one CPT?
Yeah, I mean, there typically is one, right? Because it's going to involve, it's something that is integral to the course of study and required by the course of study. There's usually some type of cooperative agreement or other type of agreement or contract between, or offer letter between the university and the company, right? So there is one. It's not like a post completion OPT where one's able to acquire it without there being a job offer.
Mhm. And then I do want to ask the other speakers, Nathan and Josh, as PDSOs from university, do you guys have anything that you wanted to add for this question? Do you need a job offer for authorizing day one CPT, and how does that work if the authorization takes months to come? Josh, I see you raise your hand.
Yeah, so it's going to vary by institution, but generally speaking, the job offer does need to be received by the DSO prior to the work authorization being approved, and the reason for that is that CPT is employer specific. So When I authorize a student for CPT, I don't just say Ryan's approved for CPT at any company in America. It's very specific to the company and a specific time frame. So for those reasons, the job offer will need to be enhanced so that the DSO knows who they're approving, what company they're approving, and for what time frame.
Thank you so much, Josh, for that additional answer, and thank you so much, Adam, for the starter to get us the comprehensive knowledge when it comes to what this rule is specifically about. So and then you guys
Wonderful.
we're going to move forward to the next session. I wanted to invite Marta to join us to speak on the second session. But thanks, everybody gives a round of applause for Adam, please, for his presentation and answering these questions. And then Marta, do you mind go ahead and get started, and then maybe we can talk about what this particular session is about.
Sure. Thank you very much, Ryan, and thanks to Adam's introduction of the new rule. Let me share my screen. Okay. All right. Can you see my screen? Okay. All right. Thank you everybody for attending today's session, and thanks to Go Elite for putting up this very timely webinar. So my session is going to be focusing on the OPT and the STEM OPT application. So before we start, just some disclaimer. It's not legal advice. I know we're gonna go over some of the concepts in the new rule, and I might answer some of the questions, but this is just for educational purpose only. Something about myself, I am based in Los Angeles. I have been practicing immigration law since 2012. I mostly specialize in employment-based immigration law, so I handle quite a lot of cases involving F1 status. So I'm a specialist certified in immigration law by the State Bar of California, past chair of the LACBA immigration law section. Okay. All right, so this is the agenda for my session today. I'm going to talk about the 6 months transition relief that Adam just mentioned. So there's this 6 months transition relief for OPT application. Personally, I feel like this rule, like this transition relief for OPT, is one of the biggest benefit for those who are still in duration of status on the effective date. But this benefit and this date is not mentioned enough in the media, as much as it should. So I'm going to talk a little more about this transition relief and also the expectation about filing I-539 together with the I-765 for the OPT application. And also I'm going to talk a little bit about travel. Nothing too special about traveling during the OPT application, just the same as the extension of status application for the F1 status generally. But I'm gonna cover that a little bit as well. I may not talk much about CPT because we know the next speaker is gonna be focusing on the CPT. Okay. So this is the date, all right. So we know that we talked about the effective date, September 15th, 2026 a lot, right? Because that's the date when this rule will officially take effect. But this is the date that for everyone who will be eligible to apply for OPT by like June next year should remember. This makes a huge difference. If you file OPT application or STEM OPT application before this date, then you are exempt from filing additional I-539. And if you file the OPT or STEM OPT application after this date, you will have to file the I-539 together with the I-765. Huge difference. I don't think a lot of the students are aware of how much difference that makes, okay? So on the face, it looks like, well, it's just one more form to file. Maybe I will have to pay some extra fee. I will have to pay 400-ish as extra filing fee. But, just one more step to take. It makes a huge difference in terms of the kind of scrutiny you get from USCIS and also timing-wise. Like, how does that affect the timing of the approval of your OPT. So currently, we know OPT is eligible for the premium processing. So currently, if you pay some extra premium processing fee, you can have your OPT adjudicated pretty swiftly. But currently, there's no premium processing allowed for the I-539 for F1 status extension yet, which means you have less control over how long it's going to take your OPT to be adjudicated. And plus, the I-539 would require your biometrics to be taken. So fingerprints, okay? So that's another layer of complication because you cannot just choose when to appear for your biometrics appointment. You need to wait for the USCIS to schedule you an appointment. And as we know, there will be a lot of filing very soon, if somebody's program is about to end. So with this surge in all these appointments for biometrics, the facility is just the same number, we have the same number of facilities. Would that lead to delayed scheduling of the ASC appointment? It could be. And the delay in the ASC appointment scheduling could lead to prolonged processing of the I-539. So there's some uncertainty there for sure. And the rule also mentioned some applicants could be even called for an interview. It doesn't say like everybody's going to be called for an interview, but some, so a lot of extra scrutiny. And I-539 is also one of those application type that would be subject to more discretionary analysis by USCIS. So, a lot of things that's not really considered in the adjudication of I-765 would be considered during the adjudication of I-539. So it's not just a little more filing fee, one more form to fill out. It actually means way more scrutiny and also way more like processing time. At least there's a lot of uncertain factors going into this extra filing of the I-539. So for those students whose program end date next year is before June the 16th, or whose OPT, like the first 12 months OPT expiration date is before June the 16th, do take advantage of this transition relief and file your application timely. But also, I need to caution everyone that to file for the OPT or the STEM OPT extension, you still need to file within the 90-day window. You cannot file too early, right? So that's also one of the challenge. You cannot file the OPT too early. So let's say if your program end date is the end of June, then you just need to be prepared to file the I-539 together with the I-765. And timing-wise, currently the rule says the I-765 has to be filed within the 90-day window, right, prior to the program completion date or the first initial 12 months OPT expiration date. I can tell like some of the students might thinking, okay, can I file my I-539 first, right? And then file the I-765 later during the 90-day window. You probably cannot do it, okay? Because both the filing of I-765 and the I-539 requires the I-20 form from the DSO. And there's this rule stating that the filing of the I-765 for OPT has to be within the 30 days from the DSO recommendation date, like the signature date in your I-20. So if you have too much a gap between the two, your OPT is going to be denied. Believe it or not, this is the #1 reason for denial of OPTs I have seen in my practice. For a lot of students, they know like there's this 90-day window, but a lot of them don't remember that the filing date of the I-765 has to be within the 30 days when the DSO enters their signature into the I-20. So these are the dates for those who apply for OPT should monitor. Okay, and also don't confuse the 240-day work authorization extension with the 180-day extension for STEM OPT. So for the STEM OPT extension, it's still the 180-day work authorization, automatic work authorization. You cannot work beyond that date. So those are the things you need to remember. And for those who are eligible for this March 18 relief, make sure there's no travel between the effective date until the filing date. Because if you travel, then you would have to follow the new rule. Okay, you will need to still file an I-539 with your I-765 if you travel in between. So you need to still be in a valid F1 student status, duration of status on the effective date, no travel between that date until the filing of your OPT application. Then then you're eligible to file, right? The 90-day, like the earliest day you can file for your OPT or OPT extension is before March the 18th. Then you can benefit from this 6 months relief. And if you are eligible, do take advantage of that because that's a huge benefit if you can skip the filing of the I-539. Okay. All right. And something else is about expectation. As I just mentioned, there's no premium processing for the I-539 yet. So you probably need to plan ahead. Currently on the USCIS website, they usually recommend the filing of I-539 for much earlier, but remember, OPT has this 90-day window. So the filing of the I-539 for OPT would be very different from the filing of I-539 for in other status or in F1 status, but with some other sort of work authorization, such as the on-campus employment or the CPT. That's very different. You have this 90-day window you still need to follow. Okay, and just same as the other extension filing, if it's denied and if the previous I-94 has already expired, then the student would start accruing unlawful presence. No additional grace period following the denial of an extension after the I-94 expiration date. Okay, yeah, so this is a date. It has to be 30-day from the day DSO enters the recommendation for OPT. Please do remember, after you get the I-20 for the OPT application from the DSO, just arrange the filing as soon as possible. Don't sit on it and do other things and come back, and then you might miss the 30-day window. Okay, travel. You can travel. Okay, travel is not gonna lead to abandonment of the extension filing. Not the I-539, not the I-765 either. However, don't be confused, okay? When it says you can travel during the pendency of your extension filing, it doesn't mean you can file for the extension outside the US. All right, you still need to be physically in the US at the time of filing, and then you can travel. But in order to come back, you still need to have like the valid F1 visa. So that part is the same. This rule doesn't really change all the requirements of anyone enters into the US. All the documents requirements remain the same, and CBP would still need to check if you are indeed a bona fide student. They have all the authority to do all that kind of check. So just remember, leaving the US wouldn't lead to abandonment. However, the rule does mention a circumstance where the CBP, right, when you come back, you have the new I-20, CBP admits you on the new I-20. So you get a new I-94 from the CBP already, which renders the previously filed I-539 at USCIS kind of like a moot. You don't need that anymore, right? So that's in that kind of situation, your filing with the USCIS would be considered abandoned because you already get the new I-94, but your EAD would continue to be processed. While you're away, make sure you take all these receipts with you, the filing of the extension with USCIS. You need to take all of those with you as part of your travel document. Okay, so that's what I have today about the OPT part. And if you have any questions, please let me know.
Thank you so much, Marta. And I love it that you not only you covered solutions for those who are currently on OPT, you also touched on the ones that who is going to apply for the OPT side. So that is definitely going to be helpful because I believe today's audience, we have people from all over different stages in their academic journey. And then I believe that, this rule when it comes to extension of stay is going to apply for everyone. So thank you for that. And then when it comes to questions, we did have collected a lot of the questions. Some questions are from previously. So guys, if you do have particular questions on the OPT side, stand OPT, anything that are related to OPT, definitely feel free to send them in also. We're going to review them as well. So let's do this. The first question would be, this is a question from Lakitha. I hope I didn't butcher your name. If I did, I'm sorry. Then he said, I am currently on my initial OPT, which expires next year, February. I recently accepted a full-time position. Congratulations. And then I'm going to start the work this year in August. As part of my job, I may need to transfer to Canada. So this is actually kind of a more unique situation, transfer to Canada for business meetings with the new rule scheduled to take effect in September. I have a few questions. So will these short business trip to Canada have any impact on my F1 OPT status or my future STAN OPT application under this rule? Actually, good question because a lot of people are expecting to travel, no matter if for business trips, for personal, anything like that. But what do you say to these kind of cases, Marta?
That's a great example about this OPT relief. So because the student's OPT is going to expire on February the 6th, so you will need to file the STEM OPT application before that date. So that's before March the 18th. Then you can benefit from the relief, 6 months relief rule. And then as we mentioned, traveling during the pendency of your like the OPT extension application wouldn't really affect the adjudication. So you're free to travel. But when you are traveling, right? Like every time you are intending to enter the US, you're still subject to the check of CBP. You need to show that you have always been maintaining status in the US. So that part remains the same. But yeah, you can travel. Travel alone won't lead to abandonment of your application.
Right. Thank you for that, Marta. Let's go to our, sorry, I couldn't talk today. Let's go to our next question. Right now, I'm on STAN OPT. My STAN OPT is going to end in February next year, but I'm planning for a PhD earlier, January in 2027. What would the changes be for my case specifically?
Sorry, which one is the, oh,
Right. So the one that we're answering live, I can read out the question again. So right now I'm in STAN OPT. My STAN OPT is going to end February 2027, but I'm planning to PhD in January 2027. What will be, I guess, the general changes for my case?
mm, right. So if your OPT, so it sounds like the person's going to enroll in the new program prior to the end of the OPT.
STAN OPT, yes, the OPT
Right.
extension.
Right. So if you are going to do that like after September 15th, the effective date, then you will need to file for the extension application. So you probably need to plan ahead how this is going to affect your work authorization. Like if you're just planning to study after you get enrolled into the PhD program, I think that's easier. But if there's extra work authorization required, and especially if it's not like some sort of on-campus like employment, that kind of becomes really complicated. So timing-wise, you need to start planning ahead. And back to I need to add something about traveling because I think I don't want to make it oversimplified. Besides all these regulations from the F1 rule change, when it comes to travel, always make sure there is nothing else in your immigration history that can cause trouble on your way back, right? Something like prior criminal record, right? Something like prior status violation. So all these other immigration status history need to be considered before you plan for any trip.
Absolutely. Thank you, Marta. Let's do maybe two more questions. This question is from Adam Johnson. So the question is about if there is an F1 student who's currently in US on OPT right now, which ends on September 15th, will likely to stay with the US in the US from the PhD program. Can he start PhD by following CVIS 5 months rule? So he can start fall 2, which starts October, so he will not overstay and abide by the new DHS new guidelines.
Yeah, so that rule would still be here. So the 5 months rule is gonna stay. For this person, it sounds like the person may get enrolled before the effective date. I'm not sure if that's the plan.
So the
And if so,
program
yeah.
start date is October 26th.
So I guess it's like when are you gonna complete this transfer
Right.
process, right? If you're gonna complete the transfer process prior to the effective date, then the old rule applies. If you wanna do the transfer after the effective date, then you need to follow the new rule.
Sounds great. Thank you, Marta. Let's move on to the next one. So this person, Addison G, is curious in currently on my second master's already, and will be graduating in August. Can I start a third master program right away after the graduation before the effective date, September 15th?
Okay, this is something I know another speaker is going to cover very soon, but I want to also inform those who plan to get like a second or even third graduate degree, like at the same level, that just because the rule says they're going to not count the degrees completed prior to the effective date toward the degree limit, doesn't mean DHS is going to always approve the EOS. So let's say, for example, someone, like say for this case, if somebody wants to file for like extension because they are going to enroll in another master degree and they already have like one, right? Then USCIS would still need to look at, let's say, whether they meet all the requirements, because F1 students still need to maintain their non-immigrant intent, right? They still need to be a bona fide student. Like if you do that kind of enrollment after the effective date, right? Then that's definitely going to be something considered. If you do the enrollment like before the effective date, then because you don't have to go through the filing with USCIS, so at least this is not something that's going to be reviewed now, okay? But you still need to file for extension at the end of your program end date, like by the end of your program end date. Then at that point, you need to show like, okay, why are you pursuing a fourth degree, right? So that's something you are just postponing. If you enroll now before the effective date, you're just postponing this question, like this issue, to a later date. So if you file after, right after the effective date, then you're gonna face this issue sooner.
Absolutely. Thank you so much for that comprehensive details. And then maybe we could do one more before we transition to David, who's going to speak on the more on the day one CPT side. So next question is on Nitant, was asking, does the CPT have to be active before the STEM EAD ends, or could it start after the EAD end date in order to keep working for 240 days while the EOS is pending. So I guess this person is transitioning from an OPT to I guess a day one CPT or a regular CPT situation.
Okay, I believe there's some misunderstanding of the 240-day rule here. Okay, I know we have another speaker who's going to talk about the CPT in particular, so I'm sure he will cover that. But just remember, for the 240-day automatic extension of the work authorization, it's extending your current work authorization. For example, if you currently have on-campus employment, it's going to automatically extend that while the EOS is pending, right? And if you currently are working under CPT, it's going to extend that. But looks like you currently work under STEM OPT and you're now applying for CPT. So unless my interpretation is that unless DHS has some rule to include this kind of scenario, otherwise it doesn't seem to be one of the examples like listed under the 240-day automatic extension rule.
Sounds good. Thank you so much, Marta, for your answers. And then everybody, please give Marta a virtual thumbs up. If you learned something from the OPT side, definitely see a lot of clapping coming in. So thank you so much. And then feel free to hang around for the future sessions as well. Right now, we're going to welcome our next speaker to joining us, David Glockman, immigration attorney, and then he's going to specifically talk about the day one CPT. I know that today a lot of audiences come in with questions in mind around the day one CPT area, around how do you transition from a previous status to a CPT. So definitely welcome in, David, and then you can go ahead and get started for our next session.
All right, thank you, Ryan. Let me go ahead and share my screen here and we can go ahead and get started. Let's see. All right, hopefully that works. All right, so I don't want to repeat too much of what everybody else has covered. You've already gotten a comprehensive view of the generalities of this new rule. Marta just talked about the interaction of this new rule with OPT and some of these other ancillary things. And I did hear a lot of people that have questions about something that I'm going to touch on. So before that, let me introduce myself. I'm David Gluckman, and I am an immigration attorney and a director of the Immigration Practice Group at McCandless Holton, which is a law firm in Richmond, Virginia, but we represent people around the country and around the world. I have a particular interest in helping people with the day one CPT process because our immigration system is woefully inadequate in terms of providing people with the opportunity to actually put to use the education that they've gotten in the United States. The H-1B lottery is not does not have enough visa numbers available, and it's just really unfortunate that a lot of people are all dressed up with no place to go. So day one CPT has been a mainstay and a nice alternative basis for work authorization for people who are shut out of the lottery and bereft of other options. But then we have this new rule coming out that we were really worried was going to sort of derail this potential option. When the proposal was released, it looked like there was going to be a categorical prohibition on anybody from enrolling in a second master's program or to do so-called reverse matriculation. Like, for example, if you have a master's and then you want to go back and get a bachelor's or get an associate's degree, it seemed like that was going to be categorically prohibited. But fortunately, when the rule came out last week and we took a look at it, it's not nearly as draconian as we thought. So let's get into the presentation here. So the final rule, it ends duration of status and it caps F1 students at 1 degree per academic level, but only prospectively. That means going into the future, right? So what the rule says is that if you are completing your degree by the September 15th, 2026 effective date, then you can get a second master's. You can go backwards from master's to bachelor's, okay? So it depends on whether the degree is completed by September 15th. So the vast majority of people who are listening on this Zoom today, you're not going to be affected by this prohibition. So a prior master's that's earned by September 15th, even if it was on September 15th, that allows you still under this new rule to pursue a second one. And we'll talk about the logistics and considerations of that in a second. And day one CPT master's programs are going to remain open to these students. So let's say that you completed a master's degree and then you don't get selected in the lottery next year, then even after that new rule takes effect, as long as your master's degree was earned before September 15th, then you're still going to be able to enroll in a day one CPT program, and that'll be an option for you. So the eligibility under this rule, under this new regulation, it turns on when that earlier degree was quote unquote completed. Now, the term completed is not specifically defined in the regulations, but traditionally when something is completed, it's generally deemed to be when the DSO completes the record in CVIS. So that's something that you talk to your school about to identify the specific date of completion. And if it happened before September 15th or even on September 15th, then you're still going to be able to go either sideways, get a second master's, or go backwards. So in my example here, you complete your master's degree on August 15th. The new rule still allows you to go for a second master's degree because you completed that degree prior to September 15th, which is that cutoff date. All right, so with that being said, all right, so we've already established that you can still get a second master's degree, and that's wonderful. The question is timing. What should I do? Should I try to enroll before the September 15th effective date? What are the advantages of that? And the answer is that if you are considering a second master's program, you've been admitted, then I think it's very advantageous to get that I-20 issued before the September 15th effective date, even if the program start date's later. Why is that? It's because then you're going to be under the current system, which allows for that CVIS transfer internally between schools. So you're not going to need to file for an extension of status. You're not going to have to submit anything to USCIS. It is all going to be done internally. So there is a huge benefit of doing that. Now, let's say that you can't get your I-20 issued, you can't enroll by September 15th. Well, that's okay. We've already established that you're still going to be eligible, but the difference is that you're going to now need to file an extension of stay on Form I-539, and that is going to be submitted to USCIS. The preamble to the rule specifically said that they haven't really established premium processing yet. That doesn't mean that premium processing is not going to be available. It just means that for right now, we have to assume that it's going to be under regular processing, and the time frame for that is very long. But what some of the prior speakers might have said is that you are still going to be eligible to begin enrollment and start studying in that new program, even while you're awaiting a decision on your I-539 application months later. So this was a question that came up at the end of Marta's presentation, is what is the EOS looking for? What is USCIS going to check on? Well, generally, what they're going to be looking at is sort of just a checkup on your immigration status. So they're going to want to see, do you have a valid I-20? Have you been maintaining your status? Have you had any criminal encounters? We've seen a lot of requests for evidence and notice of intent to deny on that. So those are the general things. They're going to be looking at compliance issues. They're generally not going to be looking at the merits of your program. Now, that's not to say that that's not going to come up at all, because discretion is still involved. You are not guaranteed an approval. There's nothing in the regulation that says if you are maintaining your status and you have a valid admission, then you must be approved. No, immigration still has the discretion to decide to approve your case. And most of the cases, most people are not going to have any negative discretionary factors. They're generally going to be approved, but that still doesn't mean that they're not going to ask questions about your program. So for that reason, until we get further guidance through adjudication, I would still recommend including some documents just explaining why you've decided on this particular program, why it makes sense in your particular career arc, and how it all fits together. And if you put that in there, then you could possibly hold off an RFE if they're going to be issuing that on that issue. Now, what happens is once your extension of stay is approved, then you're going to have on the bottom of that approval notice a new I-94 card. And that I-94 card is going to have a specific status expiration date, as some of the earlier speakers have discussed. It's not going to be for duration of status. And then unlike the people who are grandfathered and who currently have duration of status, they have a 60-day grace period. under this new rule, you're only going to have a 30-day grace period from the end of your program completion date. So that's a significant disadvantage to doing it. But still, at the end of the day, the day one CPT second masters are going to be an option for you. It's just that if you're going to be doing it after September 15th, you'll have to submit this paperwork to immigration, and then you'll get an approval that has an expiration date instead of duration of status. So again, when you're thinking about timing, if you have if you have an offer open and you're ready to transfer, I would recommend getting that done before the September 15th effective date so you can avoid all the uncertainty that might come about with this adjudication process for the extensions of stay, which again, we really don't know how it's going to look in practice. It's going to take a few months before we see how these actual situations play out. Now, those are for people who aren't already enrolled in a day one CPT program. So what if you're already enrolled in a day one CPT program? Well, again, when this rule came out, we were really worried about, are they going to just terminate this option altogether? Am I going to even be able to complete this program? Well, the good news is that the final rule doesn't have any of those horrible provisions. If you're already enrolled, this rule is going to allow you to complete your program. It's not going to retroactively end your program. You remain in valid F1 status. And if it's your first master's at a level and you're getting day one CPT, you're still going to be eligible for post-completion OPT. Now, that doesn't mean that you should just crack your knuckles, put your feet up on your desk and relax. No, we are still in the Trump administration and we are still under a microscope. So the same things that we've been saying for the last couple of years are still going to be the case. You're going to want to maintain your status and maintain documentation showing that you're maintaining your status. So if you're on a day one CPT program, you're going to still want to keep a full course load. You're going to want to attend all the in-person components of your classes. You're going to want to maintain documentation about the legitimate use of CPT. So the letters that the authorization you got from your school, a letter from your employer that confirms what you're doing and that it's related to your program. And you're going to definitely want to have those as soon as you can get them, because the last thing you want to do is graduate. Years later, you're applying for your green card or you're applying for an extension stay, and then you need those documents, and the people that you were working for or people in the school, they don't exist anymore. They're not there anymore. They're hard to find. So get contemporaneous documentation before you leave so that you have this assembled in order to strengthen your cases and your eligibility for future options going forward. So clean, well-documented status is your best preparation for the first EOS review if you're going to be doing that, or if you're going to be changing to another status like H-1B or ultimately the green card, you're going to want to remain vigilant and have these documents at your disposal. All right, so what are the realistic next steps? So who are the people who should act before September 15th? Well, those are the students that are ready to start a second master's and who completed an earlier degree before the effective date. So if you're ready to enroll, don't wait. You want to get that enrollment completed, that CBIS record transferred before that September 15th effective date, so you don't have to even deal with the EOS process. You can just get that done internally through CBIS. Who can afford to wait? Well, people who are still maintaining their day one CPT status or you're enrolled in a degree program, you'll want to focus on your records and preparing for future EOS or for OPT or a green card. So you'll maintain all those documents so that you'll be best positioned to be able to change your status in the future. So that's all I've got for this. I want to make sure that we have a lot of time for questions because I'm sure there are a lot of those in light of all the changes and all the information that you've heard so far.
Thank you so much, David. This is very good when it comes to on a higher level, demonstrating what this rule might potentially impact candidates for day one CPT. A lot of the audiences today have already speak up and ask questions around day one CPT areas. So they're coming from different backgrounds like OPT, standard OPT, or currently in the day one CPT program looking for their second program right now. So as the questions are coming in, guys, I wanted to ask you guys if you could do me a favor, go to the Q&A box. Right now we see some new questions. If you can take a look, see if that same question applied to your case, give it a thumbs up. So me and David, we know which question kind of to prioritize on. So I'm going to just go by order and you guys could do what you do to kind of make it more obvious for the next ones. So let's move on to the next one. Next question. I am on F1 from the last 4 years and studies English language programs and maintain my I-20. My I-20 is going to expire soon in October. Should I start applying now and get my I-20 for another year in another program? And then also I have applied for my other green card applications. I have done my biometrics. Those are kind of the contests. But I guess the overall question is, I have been in the language programs that expires in October. Should I go ahead and apply for a new program and get my I-20 now?
Well, I mean, I think this question goes beyond just the context of this presentation. You got to think about overall, if you've already applied for a green card and you're going to want to apply, let's say that you're able to even get the CBIS record transferred before the September 15th, 2026 effective date, you're still going to need to sign an I-20. And on that I-20, it requires you to confirm that you are a non-immigrant, that you intend to depart the United States. If you've already applied for an I-485, then you've definitively shown that you have an intent to be an immigrant, to not depart after your studies. So the risks of doing that are pretty high because the Trump administration could see that, and I can see very easily them seeing this as a potential misrepresentation. So that's something you're definitely going to want to consider. And it's going to be even more heightened. All right. So, okay, maybe just the CBIS transfer is not a big deal. Well, after September 15th, if you end up having to file for an EOS on Form I-539, well, guess what? One of the questions on that I-539 form asks if an I-485 has been filed. And that's going to lead to almost an automatic denial because you're not a non-immigrant. You are an immigrant, and they're going to say that you don't have the intent to return to your home country. You've already sought permanent residency here, and that's going to just cause a lot of issues. So my recommendation would be to consult with an attorney about your specific situation, but to decide whether it's even worth these types of program transfers, because for most people, you are authorized to enroll and to take classes while you're on your I-485. So definitely something you're going to want to look into and go through all the various circumstances of your situation.
Absolutely. Thank you, David. We do see a couple new questions coming in. Let's go to the next one. Can I get an I-20 before September 15 this year for a program start date next year? Ideally,
No.
could this person? No. So that's a hard no.
No, I mean, can you get an I-20 before September 15th for a program that starts after September 15th? The answer is yes. However, there is a rule that is existing, that's not changing, that limits transfers to classes that can start within 5 months of your prior I-20 completion date. So let's say that you have a September 15th, but before September 15th, let's say it's September 14th, they issue an I-20 for a class that's going to start in January. That's fine because it's been the 5 months. But if it's anything after the 5-month period, it's probably not going to be applicable.
Right, and then I also see a similar question coming from YouTube side. This person was asking if my stand OPT expires, and then I wanted to get a offer letter for now and then enroll full next year. And then the answer was no, you cannot do that because it's already like a 1-year gap between the transfers.
Yeah, unfortunately,
yeah,
you'll have to file an EOS when your STEM OPT expires. Yeah.
Right, absolutely. Next question, we kind of touched on this with the previous sessions, but asking for David, can you travel on day one CPT? If you travel in December, does your I-94 automatically get the end of program date for the duration of status part?
Yeah, I mean, it's not just day one CPT, it's any F1 student or J1 if you have that status. If you travel and you re-enter after this rule takes effect, so anytime after September 15th, then guess what? You're under the new regime. You're going to get an I-94 card, an I-94 record that does not say DS. It's going to have a date certain on there, and it's going to be the date, the end date on your I-20 form. And then you'll have 30-day grace period from there. So, yeah.
Absolutely. All right, let's go to the next question. This question is from Advais. Looking to apply for day one CPT PhD or doctoral program starting next year, January. If I am proceeding with the natural progression of a higher degree, like this person is coming from a master to a doctoral, any guidance on if the day one CPT requests for EOS that have a high probability of rejection. So I guess anything that they should watch out for when it comes to being compliant, and is there any red flags when they're doing the transition? I guess coming from a master point of view to a day one CPT doctoral point of view.
Yeah, I mean, I think that that is part of the normal degree progression, and so this person would need to file for an EOS, and obviously, part of that is they're going to be reviewing your immigration history to make sure that everything was on the up and up. And if you did do CPT during your master's program, they might ask for documentation showing compliance there. But apart from that, I think that it should be generally a clean case. But that doesn't necessarily mean that it's automatic. So you still should probably include all the admission paperwork. You should include a letter explaining your career progression and why this PhD program is important. And also, it's all important to note that if it's a PhD program, even if your EOS is approved, it's only going to be approved for a 4-year period. And that's ordinarily not going to be long enough for a lot of people to complete their PhD program. So if you're 4 years into your program and you still need more time, then you are going to need to file an EOS, and you're going to need to be able to show justification for that. I think that for normal people in the PhD program, I think those should be pretty easy. But if in a different situation, if you have a 2-year master's program and you're not able to complete the degree by the completion date, it's going to be a lot more difficult, I think, for USCIS to agree that you need more time. You'll really need to have some compelling consequences, I think, some compelling circumstances is what they say in the regulation. So, but generally for a situation like yours, I don't think I would be particularly concerned, apart from just the processing times from USCIS.
Absolutely. Moving forward, next question from this person. If a student's I-20 has already been extended once before, is it possible to extend it again after exceeding the standard 4-year program list? This is very particular. This is a good question too.
So are we talking about before September 15th or after September 15th?
I assuming that this is like after the rule.
Yeah, I mean, after the rule, if you need additional time to complete your degree, then you're going to need to file an EOS, and you're going to need to show compelling circumstances. I think some of the examples they gave in the regulation are, if you have problems with research, issues with, some of the courses not being available, that type of thing. So if you have a real reason for needing that more time, you need to be able to document that. If it's just that they said in there, if you're being lazy or you're not taking enough course load, then that's going to be a situation where they're going to probably deny the EOS. But if you're in one of those, I know a lot of schools, they just issue I-20s on a year-to-year basis, even though they're going to extend for a 4-year period. If you're in one of those schools, I would strongly recommend that you contact the DSO and say, look, you're going to give me these year-to-year extensions anyway. Just give me the full I-20 end date before the September 15th expiration effective date of this rule, so that I don't have to file these EOS applications in the future. So if you're in one of those schools, definitely now's the time to reach out to your international student advisor to sort of preempt the need to have to make those filings if they're just going to authorize them anyway.
Mm-hmm. Sounds good. Next question is from Han. This is also a more unique question. If a current F1 students get admitted for durational status, taking an annual vacation after the new rule takes effect, and that vacation requires the I-20 program end date to be extended by 3 months, would the student remain under the durational status transition rule or need to file a Form I-539?
Look, if your I-20 is extended and that extension occurs anytime after September 15th, then you're going to need to file for an extension of status, extension of stay. If you can get the extension in place before September 15th, then there's no need to do that.
Right, that's a general rule that you can apply for a lot of situations, definitely.
Mm-hmm.
And then let me just quickly hit refresh. And then guys, if you have day one CPT in particular questions coming in, you can definitely feel free to send it in, and also feel free to give it an upvote for some of the questions that we're being answered right now. My program end date is December 2028. So for those of you who might graduate later on, not right now, and I'm currently on CPT I-20. If I take a semester break next year, that will push my end date later on, would I need to apply for an EOS? I guess similar question to the last one, meaning that they would change their I-20 time based on the vacation that they take, but I assume that they will still need to apply for extension of status.
Yeah, the rule is if you're ever going to need more time, then you're going to need to apply for that extension of stay. So it's just a general rule.
Is there a particular area stating that maybe a master program will be 2 year, or is everything is going to be 4 year?
No, everybody's going to get if the so the rule of thumb is if your I-20 extend, let's say that you get an I-20 that's for they want to issue it for 6 years, you're only going to get a max of 4. Okay. If the I-20 is issued for 2 years, you're going to get 2. All right. It's all going to be keyed to the end date on your I-20. So in this example, if your I-20 currently ends in December of 2028, but you want to get extension of that end date to December, let's say 2029, you're going to need to file an EOS. All right. Anytime you're going to want an extension of that end date after September 15th is going to require the filing of EOS. Or, and I don't know if the other speakers have talked about this, you can always, instead of doing the EOS, you can depart the US and re-enter with that I-20, and you can get an EOS that way by getting a new I-94 card that will be issued through that new end date.
Right.
But a lot of people want to risk that, yeah.
Let's move forward. Next person, I am on an F1 visa. I'm a PhD student, joined years ago. Will my visa be capped at 4 years? What if I don't leave the country? Can I continue my PhD more than my 4 years end? My I-20 ends on 2031 right now, and my visa ends 2029. So first of all, let's clarify what's the differences for the visa situation versus the status situation.
Yeah, the visa is an entry document. Okay, so that's the document that you show to enter the US from when you're coming back from foreign travel. Once you're inside the United States, the visa expiration date does not matter anymore. What governs is your status. Okay, so let's say that you leave and you enter right now and you have a visa that's valid for 6 years or whatever. You're still going to get the DS, and it's only going to, and your record is going to be valid through the end date of your I-20 program. Now, if your I-20 program is going to stretch, your I-20 is going to stretch more than 4 years into the future past September 15th, then you're only going to be capped to, you're going to be capped at that September of 2030 end date. And even though there's more time on your I-20, if you want to stay beyond that, even if you have duration of status, you're going to need to file for an EOS to claim the balance of those years on your I-20. Okay, so you're only going to be here, even if you're on DS, you're only going to be able to stay for a maximum of 4 years past the effective date. And if you want more additional time, it doesn't matter that the visa is still valid. It matters what your status is. You're going to need to file for an EOS in order to finish that program if you do need more time at that time.
Sounds good. Next question. This person wanted to ask, if somebody have finished his school, actually 2 schools in the US, and then now is in his second schools in an undergraduate program, will this person still be able to apply for day 1 CPT by next year? So when you're talking about day 1 CPT, a lot of the programs are graduate levels, master's programs, doctoral programs. So if your current degrees are undergrad degree after you graduate, I'm assuming that you can apply for a day 1 CPT, but you do need to go over the extension of stay, to my understanding, because this person said his program is going to end May next year.
Yeah, at that point, if you want to enroll in another program, then you would have to file for an EOS with the I-20 from the new school, right?
Okay.
Oh, and also I want to mention one other thing in the regulation. I don't know if it's going to really affect too many people, but even with that September 15th cutoff date for those prior earned degrees, it only says that the degrees count that are earned while in F1 status. So if you might have earned that degree after September 15th and you were in H4 status or E2 status or H1B status, guess what? The rules don't say that disqualifies you from getting a second master's. So if I'm on a J1 and I complete a master's in October of 2026, so after the effective date, guess what? I'm not barred from doing a second master's because I did not complete that degree while in F1 status. It's very important to understand that. I don't know if there are going to be very many people in that situation, but if you are, then you should definitely be empowered with that information.
Right. Thank you so much, David, and everybody in the stands. If you do have questions following up for Day One CPT side, definitely feel free to click the link in the resource. You can book a free consultation with our team, and then if you do need legal help, we can guide you directly to our partner attorneys from today's sessions as well. So thank you so much, David. We're going to transition into our next session. Thanks for your time, and then it was a wonderful session, and then also the Q&A part as well. So I'm seeing clapping and thumbs up coming in. So thank you, David, for joining us.
Pleasure, everybody.
All right, so next guest, I wanted to welcome Nathan from Indiana Wesleyan University. So Nathan and Josh, they're going to speak on their perspective as university PDSOs. So basically the universities who actually kind of helps with your immigration staffs, even though they're not lawyers, but they're in touch with your I-20, they're the one that process your CPT, they're the one that's standing by your side with this extension of status situation. So definitely Nathan, you can go ahead and start with your deck, and then we'll have Josh right after Nathan as well.
Sure. Thanks, Ryan. Yeah, I don't want to spend too much time going back and rehashing items that have already been covered in the session, but just want to focus on a few common questions that we frequently see from students, current students that we're addressing those questions right now, prospective students, students that are joining us in August or September, and just kind of walk through some of those things that I think are critical just to be mindful of, and especially when you should include your DSO team in those conversations as we move forward with this new duration of status regulations. So again, like I said, just going to focus on some common questions that we see, on some common things to be mindful of, and just as I read the regulations and look through all the information, I think the number one thing to be mindful of is that this will favor those that plan ahead. The students that wait until the last moment, wait until the end of that program end date or grace period, or whatever that current status situation is. Those are the ones that are going to struggle the most with these new regulations. Those that are thinking well out in advance, planning ahead, getting those admissions offers, laying out a structure, setting date reminders, calendar reminders so that they know when to take action and when to take some of these next steps are really going to be the ones that are able to navigate this new playing field that we're working through. Just make sure you always communicate clearly with your DSO. If you're doing a CVIS transfer, make sure you're communicating with the DSO team that you're leaving, and then as well as that DSO team that you're coming into, and just make sure you understand what the guidelines are, what the timing is, how long it takes for either of those teams to process documentation, transfers out, and just kind of going through all those requirements, and just make good notes in advance so that when that time comes, you know what those actions are to take. And then just clearly document your programs. I think all three of the lawyers that have presented today, talked about that at length. Documentation. Make sure you document everything that you're doing, your program intent, your work authorization intent, all your I-20s. Just make sure that you are keeping a good, clear documentation of all of these things that are related to your immigration status. And then make sure you're checking that documentation for accuracy, especially if you take any actions here over the next couple of weeks to potentially try to add a little bit more time or to adjust a program date or a program major. Make sure that you go back and check that I-20 prior to the implementation date of September 15th to ensure that that new documentation has been updated and is completely correct. Just some questions to start to ask yourself as you're considering what you may do here in the next few days before the implementation date, and then what you might look at doing down the road. What is your current program end date? What is the end date going to be on your I-20 when we reach the implementation date of September 15th? Do you have any other pending actions on your status? I've heard all three attorneys discuss today what the impact of a pending green card or other statuses will be as you move through this journey. If you've got a pending H action, if your H-1B has been selected, just be mindful of all those other different things that are going on in relation to your immigration status. And while the DSO, cannot assist, or we would always refer you out to an immigration attorney with some of those other statuses, keeping our teams informed and aware of these different things, from a DSO perspective can help us assist and provide that guidance. And just be mindful of your long-term plans. How critical is work authorization to you as you go through this journey and make some decisions here over the next couple of months and next couple of years. and then just understand where the DSO team falls into that structure. There are certain things that we can provide guidance on, actions that we can do for you, and then times where we would encourage you to include a consultancy such as Go Elite or an immigration attorney, and just make sure that you have all those right people around you to ensure that you have a successful transition to a new program or extension of your existing status, and just going through all of those requirements. Some other things just to keep in mind, and David just alluded to this in his last session, as far as that program completion date and kind of looking at that program I-20. Just be mindful that you might have a variety of dates as it relates to your existing program end dates. And you do have that Form I-20 date. A lot of institutions then also have a different conferral date that may not exactly align with the last date that you attended classes. So you can check with your registrar team. Most schools will have you apply for graduation, and in that application process, there will be a discussion of that conferral date that will be posted on your transcript record. I know at Indiana Wesleyan, you have to apply for graduation to have that degree conferred. And often we have students across the institution that never go through that application process. And even though they've completed all the courses, and in an international student case, have their I-20 program in date pass, they've never actually had their degree conferral posted on their transcript because they did not take that necessary action that our registrar team requires. So just be mindful that there's a variety of different dates at your institution. They might all be the same, and they might be different, just depending on your specific institution that you're attending. So just look at those dates, and then when it comes time, talk with your immigration attorney when it relates to that extension of status. And if you are going to attempt to go after a second master's because you've already completed one prior to the implementation date, just make sure that you are clearly able to document how and when that degree was completed prior to the September 15th implementation. Another major thing that I pull out of the new regulations that I think it's important to share with students currently attending a program and those that are looking at future programs down the road is that component there in the regulations that says your academic performance, academic probation is not going to be considered a viable reason for you to extend your status. And so that is going to put a significant amount of pressure on you as a student. If you do ever fail a subject or receive a grade that may not be failing, at Indiana Wesleyan, that is a C- in our graduate level programs, that course does not apply towards your graduation, and it does need to be retaken in order to receive that degree. So just be extremely mindful of this as you're taking your classes. The number one recommendation is to pass all of your classes the first time and make sure you're taking good action, following the instructions, submitting assignments on time, being mindful of deadlines, and doing all those right student things to ensure that you are successful in all of your courses. And then if you do have an issue, make sure you're including DSO in that conversation to ensure that those courses are rescheduled and retaken in a timeline that will fit within your existing program end date. And so this also puts significant pressure on that final academic term, especially those of you that are pursuing OPT. There are some definite considerations there that you would want to involve your DSO if you believe that you're struggling in a course in your final academic term, and how that's going to play into an extension of status or getting that course recovered, or how it would affect an OPT application. And I believe Josh, will cover some of those components on how you would navigate a failed course and OPT application simultaneously. As we've covered at length, the duration of status regulation update is also shortening that grace period from 60 days down to 30 days. And so that is going to impact that overall SEVIS transfer process. And there's going to be a variety of factors in that SEVIS transfer process that students need to be mindful of as they're shifting from one school to another. There's already some complexity there in that process, and this will only add an additional layer or two as you are moving through. So as you kind of look through that SEVIS transfer process, the step one is always program admission. You need to be admitted to that new school before you can move your record from one institution to another. And then you're going to set that transfer out process, and you're going to set that SEVIS release date. And this is something we always really coach and try to educate students on, is that SEVIS release date can be set out in advance. So you can go talk to your current DSO and say, I want my SEVIS record to be released on this date out in the future. And then as you set that CVIS release date, you can be mindful of your current work authorization, what that new program start date that you're looking at, and then also looking at that grace period as well, and just being mindful of all of those factors, and then allowing that new DSO team, as they go to issue that new I-20, enough time within the factors that you're looking at, your existing work authorization, your CVIS, your grace period, and ensure that you allow that team enough time to secure an I-20 for you, issue that new form I-20 from the new school, and then allow you that time to go submit that extension of status. So just be extremely mindful of that process. And this would also factor in if you're looking at academic programs here before September 15th. If you're looking at a program that, let's say, is going to start, right there before that date on September 14th, or the previous week, just ensure that you are setting those CVIS release dates and allowing the DSO team time to ensure that you have your new Form I-20 issued to you and codified in CVIS before September 15th. And then now we're talking about this extension of status process. And I think there's a lot of unknowns from a DSO standpoint. Often actions with USCIS do not speak in a good way with with CVIS. So a lot of times we don't know information, or the DSO team is not alerted to information. Even if there is a USCIS action that does an automatic update in CVIS, no one tells us. There's just reports that if we happen to check, then we see that this additional action has happened. The best example is an H-1B approval. On October 1st, your CVIS record automatically updates to terminated because of that approved change of status over to H-1B, and the DSO team receives no notification of that action. So it's going to be really critical that as you're going through that extension of status process, that you communicate with your DSO team and say, hey, I have filed for an extension of status. Here's my notice that I have taken this action and I've submitted with USCIS. And then when the approval comes, make sure that you take that approval back to your DSO and say, look, this extension of status has been approved, and just providing all that documentation back to the school so that we can assist and be aware of this, journey that you're on with that application. I think we're all going to wait and see on exactly what's going to happen here as far as the communication between these EOS applications and the CVIS data that we have, or any automatic updates that the DSO team will receive. So just again, kind of reiterating a couple of those points, focusing in on step 3. Make sure you're securing that new Form I-20 for that extension of status prior, to that admit until date, be prior to the end of that grace period, existing work authorization. And again, don't set that CVIS release date for the last day that your grace period is there, because then the next, the DSO team is not going to have enough time to turn around and issue you that Form I-20 for you to go support and submit your application with USCIS. Make sure you're allowing time for all these steps to happen, because it takes time for us to review documentation. If there's an issue or a question or a documentation update that we need, you need to allow that time for that back and forth and dialogue, and to get that document to you in time to take the appropriate action with USCIS. And I think they also discussed already in a previous session that as long as you get this action done and that extension of status issued, then that 5-month rule is unchanged. So, as you do that transfer process, but just make sure you get that new initial I-20 for your extension of status, but you can still have that next program start date out there a little bit in the future, as long as it's within that existing 5-month regulation that we've been operating on for quite some time. And then again, just going back to the step 5 there, once you have that extension of status approval, within the 240 days, as the regulation has committed, that we're going to have those notifications back within the window of time that they have stated in the regulations. Just make sure that you provide that documentation back. And then just want to close a little bit on some considerations and questions that I know our students have been asking as it relates to their current academic program. And, as the implementation date states, we're going to base everything off of the CVIS data available on that date. So, the question you can ask yourself, is there any program updates or changes that you want to make prior to that date? Double check your records. Make sure your existing program end date matches your current registration. Make sure that your program matches, because any of these updates are very easy fixes today in CVIS for your DSO team. After September 15th, it's going to be far more complicated. It's probably going to require a correction request with SAVP, and then we're going to need to document when you brought that to our attention in order to make that correction. So just be extremely mindful and double check your documentation, and then any actions that you take between now and then, that are reflected in your CVIS record. If you're thinking and considering, for next semester for the fall, with the fall term beginning prior to September 15th, what if I transition from my existing master's program that I've not yet completed, and what if I just, go towards a doctoral program? That's certainly an option. Just some considerations on that transition, and I'm going to speak in general. I can't speak for all institutions, but in general, a master's program is a lower academic level than a doctoral program. So at that higher academic level, at the doctoral, admissions requirements are going to be higher. The academic expectations are going to be higher, and most schools are going to require you to submit a full new application to be admitted to that higher academic level and under the catalog requirements for that degree. So it's not just a change of program, it's not just a change of major. That is probably going to be a full new application that needs to probably begin now so that you have enough time to execute that admission and then make that registration adjustment prior to the fall term starting. If you're considering just doing a change of major and you look at some of the options at your institution, you may be able to just go ahead and adjust your current academic plan that would require new and additional courses. And that is something that could potentially extend your existing program and date. Again, I cannot speak for all institutions. Make sure that that program still aligns with, if you're on CPT, with your current employment, that there's still an alignment between what you're doing in the classroom and what you're doing at work. And then just have that conversation not only with your advising team, but also with the DSO and how that might affect your overall degree completion timeframe. And then if you do make that adjustment, ensure that you get that new I-20 issued prior to September 15th, so that new existing extended program end date is solidified in your I-20 record. I'm sure there's a lot of other things that we have not yet had an opportunity to fully tease out of the regulations here. I know Josh, I'm sure, can attest as well. We're learning, we're reading, we're doing everything we can to provide good guidance to our students. And as that we continue to learn more and come up with more considerations to think about, we will share those with our student populations.
Thank you so much, Nathan. I think it's wonderful to learn from the university perspective. I think everybody who's on this call has some relationships with your DSOs or with your current schools, and then you might be told different stories or different instructions. So it's definitely you could use these instructions, use this session as some kind of a help when it comes to navigating the new changes and understanding the new rules. So I wanted to also welcome Josh from Westcliff University to kind of speak on his perspective sides before we jump into our final Q&A of today.
Yeah, thank you, Ryan. And it's always nice to go after Nathan because he's just so darn thorough that, it makes my job easy. I wanted to talk just a little bit about OPT here. So let me go ahead, share my screen. I'm going to go through this quick to make sure we have time for questions. The good news about OPT is that it, in a large part, is staying the same as to what we're used to. It has not been directly impacted by the new rule. Pre-completion, post-completion, and STEM OPT all still exist. Here's the slide about everything that stayed the same versus slide of things that changed. So you can see it is very similar to the same process. So you're still going to need the I-20 with the OPT recommendation from your DSO. File the I-Form 765 with the USCIS. Wait for the EAD card to start working. The 90-day unemployment clock is still there. All of these things are staying the same. The differentiation is obviously, again, ending of duration of status and the transition to the fixed end date. So Nathan said it, each of the attorneys said it. Planning ahead is going to be even more important these days. And being aware of all your dates. So I'll go through if you're already on OPT and then what to expect if you're going to be applying for OPT in the future. So those of you who are already on OPT, for the most part, you don't need to file an extension of status right now. Come September 15th, when the rule goes into effect, your fixed end date will be tied to your program end date. I know there's lots of conversations to be had, and some of those conversations have started to happen already even here about whether, it's a good idea to transfer to a new program, sacrifice some OPT time. Lots of considerations to have there. Talk with your DSO, talk with Go Elite, because it's not as simple as, well, if I end my OPT 6 months early, I can start a doctor program right now. That's the simple version, but there's lots of other factors to come into play. When your OPT is ending and then you're looking for the next thing, that's where the extension of stay will come into play. And again, that's where you'll want to work with someone like Elite, talk to the new school. Hopefully you have some time, those of you who are on OPT, for us to get some case studies. Nathan said it, I will echo it. We are all learning this in real time. You're seeing us learn the regulation as we start to see the way that USCIS is adjudicating some of these things. We'll have updated guidance, and I know that Go Elite will be sure to pass that along as well. So, Nathan mentioned previously, not waiting until the end of the grace period to apply for OPT. I'm going to go a little bit more conservative than that and kind of recommend that if you are not yet on OPT, you're planning on applying for OPT after the new rule goes into effect. The kind of sequence that you see right here. So the first thing would be requesting that I-20 with the OPT recommendation from the DSO, and then applying for both the OPT and extension of status before you graduate. Updates prior to a student's program end date have always been important while students are currently enrolled. The new rule, the way that I read it, certainly seems to suggest that extensions of stay are um, expected to be done before program end date. So my request would be, you can apply as early as 90 days before you graduate for OPT. You can request your I-20 even earlier than that. One of the attorneys mentioned earlier, you cannot apply for OPT more than 30 days after the issuance of that I-20 with the OPT recommendation. So don't, request it 150 days before you graduate, but 100, 115 days before you're scheduled to graduate. That's a great time to get in contact with your DSO, request the I-20 with the OPT recommendation, have that in hand so that when that 90-day period before you graduate starts, that you're ready to apply for OPT. You can get that extension of status application in if it's necessary at that time, and then graduate and get the employment authorization. STEM OPT is going to look a little bit different as well. So the indications that we're getting right now, the way that I'm certainly reading this, is that when you apply for that 12-month OPT with the extension of stay, that you would get the 12 months. And then when you apply for the STEM OPT, you would need to file an additional EOS request at the same time that you're submitting the STEM OPT application. So it is cumbersome. It is expensive. These applications do come with a government fee that they're requesting. But that is the new norm that we're going to be living in after September 15th. So I will echo what everyone else said. Planning right now is more important than ever. But that's been said already. Ryan, we can go ahead and get right to the questions.
Thank you so much. And we wanted to get started with the panel Q&A from PDSOs from both sides. And I actually did pick up a few questions along the way that are related to the day one CPT or the graduation sectors when it comes to the dealing with students on their CVIS transfer and OPT and CPT side. I hope that if you guys could see, the first question would be from Vanshi. If I receive admissions to day one CPT while I'm currently working on STEM OPT, and already have a valid job offer and employment, how long does it typically take to transfer my CVIS record to a new school and receive an active CPT authorized I-20 so I can continue working, hopefully without interruption?
So Nathan's shocked me because he has the same, gut reaction to this that I do. Unfortunately, we're not able to do it the same day. I know that's what everybody wants, but it does take time for a CVIS record to be released from school A, received by school B, to be processed, to check all your documents, your visa, your transcripts, all of these different things to confirm that you attended new student orientation or checked in with the DSO according to the university's requirements. So it's going to vary from school to school. It's not going to be the same day. There is going to be an employment gap. At Westcliff, we have it set up so that once you do get that initial I-20 with CPT, we authorize through university breaks. So this would be the only break during your program of study at Westcliff. We recommend that students transfer their CVIS record to us no later than 1 week before the start of the program. And with the new EOS requirements, we may have to adjust that to allow students time to file for their extension of stay after getting their transfer pending I-20 as well.
I was going to say, I think in the past we've been a little bit more generous in trying to pull off a quicker turnaround. But I think we're all going to need to look at this and see what the timing is and ensure that students are set up for success. And I think with your employment, you're just going to need to start that conversation early, not only of, will you work with me on CPT? Are you willing to, keep me on under CPT, but just will you allow this short break, from that CVIS release date to ensure that I can go through all of this process to ensure that I do it well, have the right documentation, get the right submission, include your immigration attorney in this extension of status. As it kind of laid out in that steps 1 through 5, it was steps 1 through 3. And now we're adding more complexity, more layers to this whole process. And just make sure that you're always allowing yourself time and the DSO's time and your immigration attorney time to ensure success.
And one thing I'll add too, as someone who leads the department and Nathan does this as well at Indiana Wesleyan, generally an employee asking for 1 to 2 weeks off is a very reasonable if it's done early. If somebody comes to me and says, "Hey, in 3 months, I'm going to need to take 2 weeks off," okay, fine. But when somebody comes to me on Wednesday and says, "Hey, I can't come to work Monday and I don't know when I'm going to be able to come back," that's when issues arise. I know that it can be scary, to speak bluntly, but have those conversations with your employer early, and that's going to serve you later on.
And I think the advantage will be most people that are going through this process will be cutting short their OPT by a few weeks or a month to allow for this, which should, get them out in front of that existing end date to get that extension of status submitted. But I think Josh and I have been texting back and forth during this entire session, just as we've been asking questions. And I think some of this we're just gonna have to wait on SEVP, and their session and information to the DSOs is not coming until August 31st. So a lot of us are just still waiting on additional guidance, and I'm sure things will happen over the first few months that will lead to additional policies and clarifications and guidance. And we will continue to learn and advise as best as we can.
Right. And
Yeah,
then
I,
I
I
think,
literally had a conversation with one of my field reps today, and she didn't even have too much insights just quite yet. So all
right.
things in time.
To you guys' point, I think I wanted to give a shout out to those of you guys, students who attended today's session, because even though like the CVIS haven't briefed the information with the university side, but the students are actually proactively taking initiatives in terms of learning what's going to happen next, even though the school have limited, exposure from the government side. So that is a huge effort coming from your guys' side as well to bear with us with the whole session. So next question, I don't want to put Josh on the spot, but this is a perfect follow-up question for the last question that people was asking CVIS transfer. This person was asking, I'm starting master's with Westcliff this fall, which starts August 31st. When should the CVIS transfer be scheduled, and will we receive the I-20 before the September 15th?
First of all, excellent choice in university. It's just excellent choice. Second of all, yeah, transfer your record no later than 1 week before the start date. Make sure that your CPT application and everything is submitted, and then we make every effort to get I-20s ready by the program start date. So we can't guarantee how early it'll be, but if you transfer the record 1 week before, that's our goal, to have the I-20 for you on your program start date.
Mhm. A next question is also more on the Westcliff side. Does Westcliff give one I-20 for all semester, or one I-20 per semester? And we need to file extension of state from after the first semester, if we need to file extension of state, if we join August 2026.
We issue I-20s when there's an update to the I-20. So somebody shows up, enrolls in the master's program, and doesn't do CPT, doesn't take an annual vacation, doesn't change their concentration, they can still hold on to that original I-20. But students who do all the things I just mentioned, those are material changes in the I-20, and we do issue I-20s at those times.
I assume that this is similar from Indiana Wesleyan University as well, Nathan. Right. All right. Let's
Correct.
move forward. Let me quickly refresh. I wanted to kind of address some of the questions later on from the audiences, because those are more focused on the university and CPT side. So let's see. Okay, this question. Does your timer for OPT 90 days starts with your, it says defense date, in your graduation program, or I-20 your end dates? I guess what this person means is that, does the timer for OPT 90 days starts with the graduation dates or I-20 end dates?
For a dissertation student?
I assuming that maybe for the PhD student, for the doctoral students.
Yeah, it varies from university to university. Some will make your graduation date whatever date you pass your defense. At Westcliff, it's still tied to a session or semester. So even if if a student passes their defense today, the graduation date would still be the end of the summer semester. So you just need to talk to your DSO and find out what the end date would be.
Mhm. Next question, we're seeing also, again, visa question coming from the YouTube side and also the Zoom side. So this is like a general question for a lot of the audiences. If my visa expires before my end date, what's the next step? What should I do? If I should do anything? And then also, am I able to get my OPT approved? Am I able to travel during my OPT despite my F1 visa expired?
Now, I mean, even though duration of status is going away, you're still maintaining your status through extensions of status and additional updates, and so that you still have that valid status on your I-94, just instead of D/S, it has a fixed date. But as long as you are maintaining your status, then you're okay, even though that F visa has expired. However, the second you step outside the United States with an expired F visa, then you're required to renew that F visa, and then you'll have to go through the consular interview to have that renewed. And all of the guidance that has been offered, and visa interview coaches and other things. I believe Ryan has hosted a variety of those individuals through some of the various events that Go Elite has put on. There's still risks that come with additional degrees and extending your status, as you still have to demonstrate that academic intent at that consular interview to be issued a new F visa to continue to be able to enter and depart the US.
Right. Next question is also for Nathan. Hello, IW team. Can someone enroll in a second master, for example, like an MS program right now, and continue until December 2026, and change program from an MBA or DBA? I guess from an MBA to an MBA or a DBA. So I guess switching program from an MS to an MBA or a DBA. early next year, in January next year. Is it allowed by DSO and SEVP under old rules in January 2027?
The new regulations state that you cannot adjust your academic intent, so we cannot make that change after September 15th. If you're a current Indiana Wesleyan student, I would encourage you to check your student email for a variety of information sessions that we will be hosting later this week.
Okay, sounds great. And then I'm checking the newer questions that people are signing in. Okay, next question from Siva. Earliest date a DSO usually can generate I-20 before program start dates. I guess that varies from programs as well, but just speaking from your university's perspectives.
It varies widely, and a lot of it also depends on how early the CVIS record is transferred, how early new student orientation is. I mean, we could be our new student orientations are generally a couple weeks before start date, so we could issue after that, but that would require us to receive the CVIS record also.
Yeah, specifically CVIS transfer students, CVIS release date is the most critical thing for you to have in your vocabulary and use in that process. And if you need your CVIS record released today, today is not the day to go to your current DSO and ask for it to be released. You need to do that in advance and get ahead of that process.
And that's a great point, Nathan. Like that's for transfer students. If you're overseas and you want to get an I-20 for, you know, next May, we can do that. But once you're in the US and you have your CVIS record with a different school, it becomes more complicated.
Right.
Okay. Let's do one final question before we close today's session. I know it's been a while since we've done the 2-hour sessions, and hopefully everybody has a lot to take away to sink in. The last question I wanted to bring up is this one. Do I get another year of OPT plus another 2 years for STEM if I do a higher degree? Generally, from the practice standpoint, if they do a higher degree, how would OPT be?
OPT is one time per academic level. And just to be mindful at the doctoral level, those are usually long duration programs. And so if you use 12 months of full-time CPT while in that program, then you are no longer eligible for OPT following that degree program.
And that year is cumulative. People ask me that question, every now and then. And it's like, yeah, if you do 6 months in year one and 4 months in year two and 5 months in year three, all of those get added up. So if if OPT is important to you, especially at the doctorate level, very, very important to closely track how much full-time CPT you're doing.
Right, and then by full-time is anything more than 20 hours. So some people might think full-time is 40 hours, but it's actually not.
And yes, thank you, Ryan. And that's something where it's going to be your responsibility as an international student to be aware of that, because your employer probably won't. They will almost certainly look at something like 25, 30 hours per week and tell you it's a part-time position. Nathan mentioned earlier to check your I-20, make sure everything is accurate. We love the faith and the trust you put in us as DSOs, but it is still your record. It is still your life here. So take a few minutes, look over your I-20, make sure everything's correct. You know your situation as well as everybody else. And when it comes to the employer, the same thing. You need to educate, you need to know the regulations for international students more so than your US-based employer does.
All right. Thank you so much. I think at the end of today's session, hopefully everybody learned a lot. Myself, I also learned a lot as well. And then we want to keep this going. So in the future weeks, we'll invite various of speakers just like expert today, like Nathan, Josh themselves, and also as the other immigration attorneys that have may attended or not attended today's sessions. We want to keep those education sessions going. So definitely we're welcome to sign up for future events, and then we'll send you notification for future webinars as well. For those of you who joined later on today, we'll also send you the emails regarding the recordings if you did register through our website. So definitely stay tuned. And then I wanted to thank everybody, Nathan, Josh, and then the other immigration attorneys for joining us and speak up on the final rules and then what are the next steps. And eventually, thanks everybody who joining us as this session. As I mentioned earlier, you guys are taking the initiatives and earlier than anyone else. So this is the best chance that you guys could do to kind of overcome these challenges posted by the new rules. All right.
Thank you
Thank
for
you so
having
much,
us, Lily.
Nathan.
Thank you, everyone.
Thank you,
Thank you for
Josh.
having us.
All right. I'll see you guys soon. Thank you, guys.